You know that moment when someone gets a speeding ticket and thinks, no big deal, but then finds out it could actually threaten their green card? Yeah, immigration law has a sneaky little category called crimes involving moral turpitude, or CIMT, and it is basically the legal equivalent of a trapdoor hidden under a perfectly normal rug. The term moral turpitude sounds like something a Victorian villain would be accused of, but immigration judges use it every single day to decide who gets to stay in this country. It does not have a clean, perfect definition, which means the system has a lot of wiggle room and not always in your favor. So what actually falls into this category? Think fraud, theft, assault with intent to harm, robbery, and crimes that involve dishonesty or evil intent, what lawyers call vile or depraved conduct according to older case law that still haunts courtrooms today. Fraud is probably the most common trigger, and it shows up in more disguises than a Halloween store in October. Filing a fake tax return, writing a bad check on purpose, lying on an insurance form, all of these can be flagged as CIMT because they involve intentional deception. Theft crimes are another big one, but here is where it gets interesting. Not every theft is treated equally. Shoplifting a candy bar might sound minor, but if the statute in your state allows for a sentence of more than 1 year, immigration law does not care that you just really wanted that Snickers. This is where the concept of the hypothetical federal felon comes in, and yes, that is a real thing lawyers actually argue about. Immigration courts look at the maximum possible sentence a crime could carry under the law, not what you actually received, so a suspended sentence or probation does not protect you the way you might think. Domestic violence offenses are especially serious and have their own overlapping deportation grounds beyond just CIMT. A conviction here can trigger removal proceedings faster than you can finish explaining what actually happened that night. Drug crimes are complicated because some overlap with CIMT, and some have their own separate deportation categories entirely. Possession of a controlled substance, even marijuana in a state where it is now legal, can still create massive immigration problems because federal law is the one doing the talking here. Here is a piece of history worth knowing. The CIMT standard has been in American immigration law since 1891, which means it was written before planes existed, before the internet, before basically everything we consider modern. Courts have been arguing about what it means ever since, and the definition shifts depending on which circuit court has jurisdiction over your case. One of the most misunderstood facts is that even a single CIMT conviction can make someone inadmissible, meaning they cannot re-enter the country or get a visa, even if they have lived here for 20 years. 2 CIMT convictions at any point in your life can make you deportable, no matter how long ago they happened or how much your life has changed since then. There is a small escape hatch called the petty offense exception, and it applies if the crime carries a max sentence of 1 year or less, and you only received a sentence of 6 months or less. It sounds simple, but qualifying requires very precise legal analysis, and assuming you qualify without checking with an immigration attorney is a gamble that people lose constantly. Expungements, those legal erasures that make a criminal record disappear for most purposes, do not work the same way in immigration court. Under federal immigration law, a state expungement is largely ignored, which shocks people who believed their record was clean and their immigration case was safe. The emotional weight of all this is real, because we are talking about families being separated over convictions that happened when someone was 19 years old and made a bad decision. Immigration law does not grade on a curve for youth, for reform, or for the fact that you have been a contributing member of your community for the past 15 years. The smartest move anyone in this situation can make is to talk to an immigration attorney before pleading guilty to anything, because a criminal defense lawyer and an immigration lawyer see the same plea deal very differently. What looks like a quick resolution in criminal court can quietly become a one-way ticket out of the country. If you want to learn more about how our company navigates these complicated situations and fights for people facing immigration consequences, check out the links in the description.